Hello and happy Wednesday to all. My name is Kyle Sebastian and I am the Jed Campus Learning Community Coordinator at the Jed Foundation. The Jed Foundation is a leading nonprofit that exists to protect emotional health and prevent suicide for our nation's teens and young adults. Through our signature program, Jed Campus, Jed has partnered with nearly 300 colleges and universities across the United States to guide schools through a collaborative process of comprehensive systems, program, and policy development to build upon existing student mental health, substance use, and suicide prevention efforts. Today, we would like to welcome you to the first of our two-part webinar series surrounding student mental health and the law, which is a resource that Jed first developed over a decade ago that discusses the legal issues that colleges and universities face while addressing campus mental health and working with students in distress. For this webinar, we are joined by Peter Lake, Professor of Law, Charles A. Dana Chair, and the Director of the Center for Excellence in Higher Education Law and Policy at the Stetson University College of Law. I'm also pleased to be joined by Dr. Victor Schwartz, who is our Chief Medical Officer at the Jed Foundation. Before we launch into today's webinar, I'd like to share a couple of housekeeping notes for you all. First, if you need closed captioning services at any point during today's presentation, please use the link that was provided in the welcome message as you logged onto today's webinar. Second, if at any point you have a question for Peter or Dr. Vic, please type it into the question box on your dashboard, which we will answer during our Q&A at the end of our presentation. In a few moments, we will also be using this question feature to collect live feedback from today's audience, so please have your keyboards ready. Third, you can find a PowerPoint version of our slides in the handout section of your dashboard, as well as a PDF version of our student mental health and the law document. If you do not choose to download the handouts during the webinar, or you are listening to a recording of this presentation, you can simply ask for a copy of these files by emailing me at kyle@jedfoundation.org. Finally, for those unable to join this call live, this webinar will be recorded for future access through Jed's Mental Health Resource Center. Student Mental Health and the Law, a resource for institutions of higher education, was originally published by the Jed Foundation in 2008 as a tool to aid institutions of higher education in developing awareness of various issues and concerns relating to campus mental health and working with students in distress. The document is a product of Jed's collaboration with 18 roundtable participants, including Peter Lake and Dr. Gregory Eels, who is the current Executive Director of Counseling and Psychological Services at the University of Pennsylvania, and will join Peter as one of our presenters during part 2 of this webinar series. Additionally, Student Mental Health and the Law outlines 14 different good practices, such as encouraging campus-wide communication or encouraging students to be proactive about their mental health. And these good practices reflect the input from roundtable participants, key research findings, and Jed's other programs. For example, in addition to Jed Campus, the Jed Foundation also offers U Lifeline to over 1,500 colleges and universities across the United States. U Lifeline is an anonymous, confidential online resource center where college students can be comfortable searching for the information they need and want regarding mental and emotional health. And prior to publishing Student Mental Health and the Law in 2008, Jed surveyed campuses through U Lifeline to identify the legal and ethical issues they found most challenging in working with students in distress. So, in alignment with the original document, today we're going to ask our audience to answer the following question. Which legal and/or ethical issues do you find most challenging when addressing campus mental health and supporting at-risk students or students in distress? And so as we continue with the agenda, we invite you to take the next 60 or so seconds to submit an issue or concern that comes up for your campus or your institution using the question feature on the GoToWebinar dashboard. So for today's agenda, we will discuss how Jed's recommendations have helped to shape mental health law in the United States. Second, we're going to discuss the 4 key challenges outlined in Student Mental Health and the Law, including privacy and confidentiality, disability law, delivering mental health services, and liability for student suicide and violence. Finally, we will begin a discussion about legal implications of these issues for institutions of higher education that we will continue during the second part of our series and end with a discussion of possible future legislation surrounding campus mental health law. And with that, I am going to pass it over to Peter and Dr. Vic for today's presentation.
Thanks, Kyle. Kyle just went over today's agenda, so possibly if you could shift to the next slide. I'm actually going to take the liberty of just saying a few words about the Student Mental Health in the Law document, which was developed 10 years ago, and really has had a significant impact on some of the cases that have found their way to the courts in the last 10 years or so. In order not to seem too self-serving, I'm actually going to ask Peter to tell us a bit about the Nguyen case. We're going to discuss it a little bit more in detail later on, but it is a case in which there was reference made to this document. So Peter, maybe you can give us a quick overview, and we'll come back to it in more detail as we discuss some of the issues that were raised by this particular tragic case.
Sure. Thanks, Vic. And this is Peter. Kyle, thanks for moderating today, and hello to all the participants out there. You know, I'm reflecting back to when we first got together back in 2008, Vic, and putting together a document where we talked about promising and good practices, and sort of hoped that the work that we would do would shape the field. And of course, you never really know for sure what, if anything, the impact will be on the law. But one of the things that was happening about that time is we were waiting for the law to give us significant guidance of any kind, really, on what institutions should be doing about severe risk associated with mental health issues, particularly suicidality. And I had written a couple of articles, including one called Still Waiting, and sort of begging the courts really to come up with something, anything, to give us guidance. I think in some ways a wish came true with the Nguyen case, and of course it's, you know, it's a little paradoxical because it's a very sad fact situation. MIT, you know, had a suicide. It's not the first time they've had a completed suicide. They were back in court. If you go back in time, you'll remember that they dealt with a very difficult Elizabeth Shin matter a generation earlier. And they were tested all the way to the top court in Massachusetts in 2018 with respect to their response systems to student suicidality. And, you know, I guess the good news is that Massachusetts said that MIT won the Nguyen case, that what they were doing comported with any requirements of reasonable care that an institution might have. But I think one of the things that's the real takeaway for today and for the Jed audience is that in addressing this case, the Massachusetts Supreme Court essentially looked to what MIT was doing. And as you can see, said suicide protocols are an important part of reasonable measures in a university attempting reasonable care around suicide prevention, and then specifically made reference to the framework that was developed in connection with the variety of materials that Jed has produced. And, you know, from a legal point of view, Vic, I think what I would say is that, you know, we don't really talk about best practices per se in the law all the time, but this is as close to a validation of a best practice as you're going to get. And I think the inevitable outflow of this is, at least in Massachusetts, the institutions there will be looking at Jed materials as guiding documents and recognizing that, you know, using the framework and other materials will not only provide a safer environment, but will also potentially be helpful if there is litigation over a student death. Now, again, this is just one court in Massachusetts, but I did want to connect this, and we'll do it a little bit later, with a theme that's flying through the country. The Nguyen case held for the first time in Massachusetts, and virtually simultaneously with a California Supreme Court case, that students at college are in special relationships with their college for purposes of safety prevention. And I think what you're seeing is a shift in the law that's been, shall we say, facilitated by the activity at Jed. So I was very pleased to participate in the work that we did back in 08 with you, Vic, and I'm going to say we waited, you know, a good long time. It's been a better part of a decade but the hard work that we did back then, I think, has come to fruition in shaping the law, but more importantly, shaping institutional practice to make college safer and more responsive to student mental health needs.
Well, and as you say, Peter, thanks for that overview. And I also just wanted to point out that just a historical piece of this too is that this effort took place right after the Virginia Tech tragedy. So there was a lot of interest and concern about, you know, how campuses can and should be handling issues related to, you know, confidentiality, handling students in crisis, and, you know, what sorts of actions could be taken by a university when a student might be in a crisis. And clearly the goal of this effort 10 years ago was to really help provide some guidance to campuses in thinking through some of these really vexing challenges. So if we could move on, the next issue that we were going to quickly discuss, and for our listeners, what we're going to try to do in each of these areas is give you a quick, brief overview of what are some of the recent issues that have come up since the publication of this document. So just highlighting some of the areas where there have been either new cases that have elucidated some of these situations, just novel things to think about, and then cover really some of the highlights of the concerns in each of the areas that Kyle mentioned before that the original document takes up. So there have been, or at least there has been a new case that's come up that has, again, provided a new facet in thinking about the privacy and confidentiality issue. And I'm going to ask you, Peter, to just sort of walk us through this and what the implications are, and then we'll, you know, get to some of the highlights that people should be aware of in this area of you know, student privacy and confidentiality.
Sure, Vic. And you know, when you look at where we were in 2008, I think we identified, you know, for readers of our document that there are complex issues of foreseeability and privacy and what reasonable care looks like, and what kinds of responsibilities you might have if you have a duty or responsibility at all. And you're constantly walking on the legs of the triangle. You know, in the Wynn case, for example, one thing the Massachusetts court pointed out is that there's no legal duty to prevent every possible suicide on campus, that not everything is legally foreseeable. And so they're very specific about when our duties were triggered. But here's the thing, when we start taking information and getting concerned about issues of foreseeability, we may find ourselves prying into the privacy of students or even confidential medical records. And although that's not exactly what took place at the University of Oregon, I think that the incident or situation there became very connected to our work. And we had a student there who was suing the school in a Title IX matter, and the college took access to records, medical records among others, to try to defend itself. And there is an exception in FERPA that permits that kind of behavior, but it caused quite a backlash. The feeling was, you know, our students coming to college and using health systems and obtaining educational privacy, and then that information is actually being used against them in court when they become adverse to their institution. And the result was that the Department of Education sprung into action and urged institutions to respect confidentiality and privacy, particularly with respect to medical health records. I think this is a huge win for counseling centers, which
Yes, it is.
Really based on the idea that information should only disseminate under extreme circumstances or consent. And I think the Department of Ed really swung back and said that. And if we could advance to the next slide, Kyle, I'll show you what eventuated from this. In August of 2016, the U.S. Department of Ed issued a Dear Colleague letter and basically clarified that to use the FERPA exception where an institution might access health records in litigation, that the institution should use that in a very limited and specific way, and frankly, very narrow circumstances, essentially where the litigation relates to medical treatment, so there's medical negligence that's been alleged or some kind of payment issue. And what this Dear Colleague letter translates into is institutions should not and are guided to not engage in fishing expeditions, particularly with respect to medical health records, simply because it might advantage them in some kind of general litigation moment. And I think had this existed at the time of our original iteration, Vic, we would clearly have written this up in the document. I think at the time, it really impacts the work we're doing. And again, you and I have talked about this, Vic, quite a bit. That there's a lot of pressure on counseling centers and health providers to share data for the safety and benefit of the institution. But respecting medical privacy, I think, is absolutely paramount, because at the end of the day, the law needs to be careful not to get in the way of the people who know best how to help students on campus. And that's usually people like you, Vic, not people like me.
Right, right. So, I think we've both done many talks about the various legal and ethical issues related to college student mental health. And I have found it helpful to think about this in terms of the struggles or conflicts or difficulties come up because we have these conflicting values. On the one hand, it's very, very clear that the expectation of confidentiality and also personal autonomy for young people who are typically, by law adults, most of our students are over 18 in higher ed settings, so they are really considered to be independent and adults. And we have a tremendous amount of respect for this idea of personal autonomy. You have the right to make your own choices. On the other hand, there is this concern about, in loco parentis, what's the university or institution of higher education's responsibility to both protect a particular student, to engage a student when there seems to be distress or a crisis. And we'll talk a little bit later about when do parents come in. But what seemed unique about this case was that it appeared that they were really looking at the student's mental health records to protect the institution rather than to protect other students or staff, right? So it was being used in a kind of, the strategic way for the school to arguably maybe, cast some light or discredit the complaint of the student, which sets this case apart from many of the others that we've seen.
Vic, if I can play off a couple of things that you just said, going back to the Wynn case in particular, the court was really sensitive to the fact that they don't want to infantilize student populations, that, the period when students were treated like children is over. And I can't say this in the strongest terms, any stronger than I'm about to, that the law has shifted. This is not some return to in loco parentis. This is an entirely new way of thinking about mental health delivery. And it's very, very based on exactly what you're saying, is that we need, not just clinically, but educationally, to respect the growth and autonomy of students. And therefore, the court, I think, was very careful not to set legal standards that would set, suicide patrols knocking on doors every 5 minutes to ask how people are doing, or to, set some kind of incentive where institutions would be so afraid of legal liability that they would routinely invade people's privacy. And so I think what you're seeing is an entirely new era in student interaction with mental health law and college interaction with that. And even the lawyers' roles, I think, are changing to a more complementary role than a less competitive role. So now the lawyers on campus will be trying to facilitate good practice, not necessarily compete with it.
Well, we sure hope so, right?
Yeah,
so Kyle, if you could advance the slide, because I'm now going to sort of argue or raise the question from the other perspective, which is referred to in the first two bullets. So after the tragedy at Virginia Tech, Virginia passed a law that mandated parental notification when a student was in a suicidal crisis. And you know, they did build in reasonable exclusions. We've actually heard of similar efforts in some other states, that there have been these kind of moves towards trying to mandate parental notification. And you know, it's, on the one hand, it's kind of understandable when parents are so involved with their students, their children who are attending institutions of higher education, in spite of them being adults, technically and legally. But at the same time, do you see the Virginia law catching on? Do you see that, in fact, in Virginia, that it's actually led to specific distinct changes in practice in the institutions of higher education there?
You know, Vic, I've observed not just Virginia, but nationally, there's been a trend, at least since 2008, towards more information sharing, even mandatory information sharing. And, you know, the only caution that I put out to lawyers and legalists when they get involved with this is the decision to share information with anyone is always an act of judgment and needs to be done individually and with a great deal of care. Not the least of which is that in some cases, notifying individuals, parents, or families could actually put someone more at risk than one might imagine. It might actually put them right back into the fire in some sense. And so I've never been terribly fond of blanket mandatory reporting, because there is the potential in any individual case to cause more harm. There's also a little bit of an irony here too as well. In many cases, with certain very suicidal individuals, their family may be well aware of their suicidal ideation or intentions. In fact, in some cases, we actually hear things like, "This student is your problem now," and they literally turn people over to the institution. Yes. And so what I'm hoping, Vic, in the next 10 years is that we move from mandatory notification to more clinically driven ideas of parental and family involvement, even protective factor involvement.
Yeah.
And because, you know, you and I know this because we do this work a lot, but sometimes the person who actually needs to know the most is not a family member, but a close friend or a mentor. And some of these laws are both sort of over and under inclusive, and they're just first generation, really, is what I would say. I think the intentions are good. And of course, what's nice is that FERPA, which doesn't require reporting, has now, since Virginia Tech and the new regulations, has actually opened the door for good judgment-based reporting if institutions choose to do it. And I actually think the federal approach is a little more desirable in some cases than some of the mandatory reporting ideas that I've seen thrown around out there. And I'd be glad to discuss that with the audience a little more depth.
And I think that's a really important point to make, which we, put on the slide as a question, but I'm just going to make one or two comments about it, which is that while you hear a tremendous amount of fearful discourse around FERPA, many people will say, I can't do this, I can't do that because of FERPA. The fact is that there is really more than reasonable latitude within FERPA to use your judgment. It was actually made explicit again after Virginia Tech that as long as an institution made a kind of thoughtful analysis of the situation and came to the decision that there was some significant degree of risk and a reasonable purpose served in communicating either internally or with family, that the school would not be sanctioned on the basis of a FERPA violation. That the understanding was that schools needed the latitude to make what they thought were sensible decisions. And I also want to take that last bullet and rather than present it as a question, just make a comment that I think more and more counseling services and hopefully parents and students are becoming more aware of both the fact that we only hear about the cases or situations that go where something goes badly. In the vast majority of situations, the counseling center, the student, the administration when it's relevant, the families when it's relevant, are able to work together to, sort of come to reasonable decisions about who needs to know and do what. But it is useful for folks to be aware of advance directives that you can do consents to share information. There are advance directives that are around, including on, for example, our Set2Go website, where you can essentially create a series of parameters for when a family could be contacted. These are particularly useful for students coming to school with a history of significant mental health problems, so that you can go with some degree of comfort that we've agreed if the student stops, going to class, or depression gets to a certain point or psychosis reemerges, that the student has approved of parental contact on whatever bases were stipulated ahead of time.
Yeah, this is an excellent point, Vic, that I think as a diagnostic tool, the law would make everyone think that all of this work that we do is terribly ill and not functional, when in fact the vast majority of our work is highly functional and works routinely well in many, many cases. And I do really think the legal perspective can skew what someone's impression of what we're doing is. And I think this is why the Department of Ed with FERPA was so permissive. They basically said, if you're using FERPA as an excuse not to save someone's life, you're really sublimating an issue to FERPA and not addressing what's really bothering you. You're deflecting away from whatever real concern you have. And invariably, when I talk with an institution or an individual and they play the FERPA card, behind that discussion is usually some other concern that needs to be addressed, and they've sublimated to a legal question about FERPA, when in fact it's not really that question at all. And then, as you point out, increasingly we're able to manage mental health issues by getting in front of them, by having conversations with students. And we're moving to a system that's, a little more similar to what's happening in K-12, where we're not just waiting to therapeutically intervene at an end stage. We're actually involving ourselves in the wellness of our students as they enter and go forward. Vic and I didn't have a chance to talk about the red flagging issue that's flying around the Chronicle. Just did a story this week on that. But institutions will be reading admissions files now, and the admissions application is a suicide note. So what do? You don't just simply turn the page or not admit someone. You need to help the student. And times are changing, and I think the law has facilitated that. But I just want to echo something that Vic said is, yeah, you read the hard cases, you read about them in the newspaper, but my impression, because I'm very close to this in the field, is that 99.9% of the time, this stuff is working to help students and faculty and staff, frankly, regularly throughout higher education.
Yeah, and the fact is, again, that the law can provide these sort of outer boundaries of where you should, not go or tread very carefully. But most of the stuff that we deal with and experience work with it well within the boundaries of, you can just do what is sensible and and clinically appropriate under the circumstances, and it's important not to lose sight of that. Let's move on so we can save a little bit of time for some questions in this area. And Peter, maybe you can again update us on some of the new things that have emerged around mandatory or involuntary leaves, which is, I suppose, where we see the greatest ramifications of disability law.
Yeah, and by the way, I'll just apologize to the audience. I don't usually get a full hour to talk to Victor Schwartz, and it's such a treat. I just get excited. So I'll get back to the slides, but thanks for the time.
Sure.
Yeah, the popular press has made a big deal out of voluntary and involuntary withdrawal issues and re-entry issues, and it's become such a cause célèbre, both with case law and even with the Department of Ed, that the lawyers in the field have taken note of mental health issues. Again, I'm not sure if people know this, but at the most recent meeting of higher ed lawyers at NACUA, the college attorney group, this was a major theme, with student mental health issues. And I think, frankly, a lot of it's been driven by this voluntary, involuntary withdrawal issue. what we're seeing is, and again, we talked about this back in 2008, but what we found at the time is that people were catching up to the issue, is how do you structure a voluntary withdrawal? How do you structure an involuntary withdrawal? And what do you do with people that are trying to re-enter, so you don't create a class of academic homelessness where people are either encouraged to voluntarily leave or told to leave but can never get back in again. And this has occupied attention, particularly with the Department of Education, who've issued some interesting resolution letters. And, you know, we don't have an infinite amount of time to sort of beat these to death, but you may have heard of the Spring Arbor situation where a student withdrew and then had trouble re-entering. I know OCR was, I think, a little concerned that the re-entry standards weren't consistently applied, and made that point that you can't sort of change the rules as you're in transit with someone. It also raised an interesting issue about whether someone can be asked to withdraw simply if they cause a threat to their own well-being. And I think the concerns that came up under Spring Arbor, I think, were largely answered in a University of Tennessee Health Sciences Center resolution. And I thought I might actually show the audience some detail. I don't generally throw slides with this level of detail up, but I think people might want to have reference to this. And again, this is the sort of thing that I think would have made it into the 2008 document if this had existed back at that time. And here's
the language here is very, very useful, actually. It's, you know, it's really clear, and I think really helps to elucidate and illuminate the situation.
Yeah, I'm gonna, Vic, if I can pull one concept out of this, and maybe two. And the next slide also has some information as well, so it's sort of split across two slides, is OCR is basically saying you should be performing individualized assessments based on consistent policies that apply to everyone. But each student is unique. You can't treat people as a class. You can't throw out all your suicidal students. Each suicidal individual or person at risk is a unique situation. And the other thing I think that has emerged from the Tennessee document is that it's perfectly reasonable for an institution to set qualification standards for a program that includes self-care. And if you articulate that and it's part of the program, then that's something that one can enforce and then, you know, essentially use with the student population in a helpful way to assess whether someone should withdraw or when they're able to re-enter. And I don't think that for OCR's perspective that this was particularly rocket science, because this is something we've seen in other businesses and industries. But I think for higher ed, this is really meaningful. It means have clear policies, but use an active judgment with individual students, make a reasonable pathway for reentry for people, and if necessary, set standards for self-care and wellness that are genuine qualification standards related to your program. That's kind of the big takeaway from both this slide, and if Kyle, if you want to advance to the next, it's kind of continues there as well. And you'll notice that we should be careful in using involuntary leave. We have to take particular steps and really use reasonable care and assess reasonable modifications to determine whether that's appropriate. So it's not a knee-jerk response. I don't think I can handle the use of leave. There's actually a metric for how one is supposed to proceed with these kinds of processes. Very consistent with what we told people back in 08.
Yeah, so I think to sum that up, the idea of having a kind of tripwire policy that if a student says X, then the school can just automatically put them on a mandated medical leave isn't an acceptable approach to things, that there needs to be a process by which people are thinking about this, analyzing the situation specifically, the context. So I think one of the examples where a school has, their decision has been upheld was a student who had a very, very severe anorexia diagnosis, was not eating, was losing weight. And there was no clinician within, anywhere within reasonable travel distance of the school that the student could access. So she was really not able to get the care she would have needed to sort of maintain a basic level of health. the school was, I think, found to be okay in their decision to remove that student because it was a kind of sensible matter of health and safety for that student. It really, you need, there's this old principle in child mental health of acting in the best interest of the child. I think what the DOJ is looking for in these situations is seeing that the university has made a decision that's in the best interest of the student's health and safety and academic performance. I mean, that's an element of the decision making too, rather than the school's convenience or the school's comfort. If I can sort of bring this into one organizing principle.
Yeah, I couldn't agree more, Vic. And I've even detected, because of the work that DOJ in particular, DOE does with K-12, that they're sensitive to even implicit ableist instincts of an institution, where there might be an instinctive reaction to push someone out of the program because it's uncomfortable or it doesn't feel normative to have people with certain disabilities in a particular activity level. And when they detect that kind of ableist dialogue or instinct, they tend to react to it.
Yes.
So, I think what you're seeing is that the regulators are getting much more sensitive to how clinicians think and talk and where the science is. And that's probably the big message from the Wynn case is respect the scientists, respect the science, use the science, and lawyers are really here to facilitate the scientific dialogue, not the other way around. These rules are written not for the convenience of lawyers and litigation, but for the well-being of our populations and the good work of professionals who understand how to deliver services most effectively.
Right. And it should be a source of comfort to the clinicians and administrators out there that actually the federal government and the law is trying to induce people to make good clinical judgments, to really follow good clinical care as the main guidance. And again, is providing the outer boundaries of, if you find yourself in this space of, sending a student home against their will, then you at least ought to be thinking this through very carefully and have a very clear understanding of what's leading to this decision and what's in the interest of the student. I'll just make one other comment reminding people of a point you're well aware of, that Paul Applebaum, who's a forensic psychiatrist who's written some things and done some work around this college mental health law, pointed out in a paper called Depressed Get Out, I think it was again in the late 2000s, where he pointed out that the ratio of people with suicidal ideation to actual deaths by suicide is about 1,000 to 1, and suicide attempts among college students versus actual deaths by suicide are about 100 to 150 to 1. So again, this idea of any student who expresses suicidal ideation being, mandated to leave school would be sending home a large group of students who are not likely to die by suicide, to potentially stop the one death on campus, which, just statistically makes no sense. Of course, the problem is we can't know who is that one student within that, statistical group who might die. But, just thinking about the ramifications of those kinds of policies from that perspective helps, I think, to clarify why those kind of tripwire policies of, you have suicidal ideation, you need to leave, simply don't make sense and might not be in the student's best interest, since by and large, if a student can function in school, even if they're having a significantly hard time, if there's support that can help them through that, it's, on balance, it's best for them to be able to continue in their program if they can handle the academics and the living circumstances of being in school. So let's maybe move on so that, again, we save a little bit of time in the end for some questions. These are some quick questions, and I don't know that we're really going to be have much time, but I'm just going to raise this one because I'm kind of curious, Peter, whether you're aware of any cases that have come up or any guidance around online or video therapies, which are becoming more and more common, particularly in settings where there may be lack of access to services?
Yeah, I would say, Victor, just sort of like we were back in 2008, the legal questions are running ahead of where we have hard legal authority.
Mm-hmm.
And I'm noticing that a lot of my clients have exactly these kinds of questions. You know, precisely what kind of assessment should we do to determine whether we're going to do inpatient care or ongoing out care. The one about acceptable standards on reentry comes up all the time. And one of the problems that's fairly persistent is that sometimes you'll be able to easily get your hands on a doctor's note that says that Johnny or Sally is ready to return to school, but no one has confidence that that's sufficiently accurate or complete to actually justify people returning. And, you know, I'll sort of pause on the first two and say, you know, I think ultimately these become primarily questions for professionals who deliver the services to work with. And I think it does make the therapists and physicians and others who are delivering care nervous, but it's really a practice standard. And I think professionalism standards here predominate over legal because there is quite a bit of gray space as to exactly what is permitted. You know, again, subject to what we saw in the University of Tennessee resolution, but you see how general that is. And I think the question of you know, video and online therapy has been very prominent. And I think one of the things that people are asking is, you know, are these services helpful? How do we track them? Are they substitutes for other types of behavior? I know that many of the students are choosing to access some of these newer services, the counseling services that are available on demand. And I think that the verdict isn't in yet as to exactly whether or not this is going to be something that forms what we would call promising or even best practice. And I think this is a point of conversation that I hope that Jed can continue to facilitate. I'm anxious to hear Greg Ells on this next webinar. I think we want to sort of probe his thinking on this, because I hate to kick it back, but you know, today's big message is lawyers get out of the way, let the practitioners dictate where the future of this goes. And I think that's exactly what I'm going to do, is let's hear from the experts who deliver the services like you and Greg, who probably have the best insight into what we should be doing.
And I will say for the listeners out there that HEMA, the Higher Education Mental Health Alliance, has put out a document with some at least suggestions around the online video therapies. It really raises what are the questions you should be asking in suggesting these kinds of services and vetting these kinds of services. And, you know, it is a complicated area. There are a lot of private efforts to do this. And of course, in those kinds of private for-profit settings, you always have to, you know, the buyer needs to beware and make sure you're dealing with, you know, people who are doing this in a careful and right way. But as you say, this is still emerging areas of concern. But, you know, for parts of our country where there really aren't adequate access to services, this can really open up at least some basic level of service that can be very, very helpful to those institutions and their students. Why don't we, Kyle, move ahead, because this last area we wanted to touch on, again, I'm going to ask you, Peter, to sort of walk us through what the thinking both 10 years ago and currently, which hasn't changed a whole lot, even though there have been you know, some recent cases that have sort of taken a relook at this concern. So, Peter, walk us through.
Sure, Vic, and these are the kind of slides that I dislike when I'm an audience participant, these thick, dense legal slides. And the reason I put this back in here is, in the next slide, Kyle also has this continuing, is most of what we said back in 2008 remains true. And I thought it was worth repeating that these bases for potential liability have not fundamentally altered from 2008, but there is something that has changed. And Kyle, if we could move to the next slide, I want to sort of illustrate that. This is the SO dot, the second dot on the screen, and connects with the case before it. I made reference obliquely to this earlier, but now here it is. There was a case in California almost simultaneous with the case in Massachusetts in 2018. Not a suicide case, but a stabbing case in a classroom. And the California Supreme Court said things that were remarkably similar to what we saw in Massachusetts in the Wynn case. And I think the only reason they didn't reference Jed documents is it wasn't a suicidal student situation, but the same kind of thinking was there, special relationships between colleges and their students. And what we're seeing is something that could be a significant trend in student safety law that's happening sort of coast to coast. Will courts around the country start to follow what happened in Massachusetts and California? I should note that both of these cases were essentially unanimous and very, very broad in the language and analysis that they used. I wanted to draw attention to an article in the Chronicle by Neil Gluckman, who quoted a good friend of mine, Benjamin Sapersky, a law professor. And Ben predicts, or at least indicated, that there's some chance that these cases could be very influential throughout the United States. And so I suppose one thing that I would change if we went back to 2008, if we had a time machine, is I would say that institutions should be prepared for the fact that state law could begin to articulate that the very student relationship itself is special. And one of the things that's an implication of this, Vic, is that our interventions will not be just limited to the most severe outcomes, the unusual case of a potentially completed suicide, but we'll have to be responsive to the broader mental health and wellness issues of our community. And that's what we're mostly seeing. You know, if there's one thing that we did back in 08 that I'm most proud of, Vic, is we brought a lot of these mental health issues out of the closet. We got people talking about student mental health and not denying that this was a serious issue. And today there are more counseling service activities on campuses than at any time in American history. And I think it continues to grow. The demand often outstrips the supply, which requires online responses. But I think what you're seeing is the law and Jed and frankly our industry have been moving towards recognizing that student wellness broadly conceived is a major issue in education. The tip of the spear obviously is suicidality, but not the only thing that we'll be limiting our attention to. And that would be the major update I would do if we went back and tinkered with the 08 document.
So I will say, as kind of a corollary, Peter, to what you've just said, that I think one of the things that was really great about the effort 10 years ago, and actually has been really gratifying about the conversations that have happened in these issues since then, is that the people on the legal side of this, like you and Gary Pavella, and I guess, you know, people, Gene Dysinger, who's kind of in the security legal, but clinical side of it, have been very, very attuned and really understood the primacy of the clinical piece of this, of the, you know, the best interest of the student being the main concern. So, you know, the conversations have, you know, very often the lawyers and the clinicians in these situations talk past each other. And I think this was a circumstance in which there was a really positive and really productive meeting of minds. And that's been reflected, I think, in the, you know, the efforts and the statements of the DOE and the DOJ. They've been very, very careful and very thoughtful in the way they've really tried to address these things. The one interesting thing to me about, specifically about, you know, the Rosen and the Nguyen case have been that while they've used this language of the special relationship, the way they described what that is I think very, very in line with the way all of us have been talking about what the institution's responsibilities are, even without the, you know, that idea of that special relationship existing. So they've added something that raised some eyebrows and maybe got people a little bit anxious, but they used it in a very, very, again, thoughtful, reasonable way, at least to my mind.
Yeah, Vic, I know time is of the essence, but this could be the capstone point for this particular webinar, that I think Jed facilitated the conceptualization of the college-student relationship in a way that's very modern and very unique, and not based on some kind of ancient family paradigm, but based on the actual reality of clinical needs of students today, the way they're coming to school, and who they are as forming adults. It's the birth of something entirely new. After almost 1,000 years of law that went one way, we now have created something. And I think Jed should take a lot of credit for helping lawyers and legalists understand the need for and the appropriateness of truly reconceptualizing the college-student relationship, and how important caring for our students is to their learning, that these things go hand in hand. So I've got to compliment you for that.
Well, we certainly appreciate the support, and actually appreciate your role in really helping to flesh this all out and illuminate these ideas as effectively as you and the group of people who did this have done. We are down to the last 10 minutes, so maybe ought to save this remaining time for any questions that seem kind of urgent. There will be, as Kyle mentioned, a part 2, which will be, I think, all a Q&A format. So those of you hopefully will be able to tune in for that in several weeks. But the one issue we haven't touched on and really is a change, and maybe you could make a couple of quick comments, Peter, about your sense of how behavioral intervention teams have sort of developed, and are there particular concerns, and how difficult have these been for universities to manage?
Yeah, I mean, I remember when the big push for BIT and care and threat assessment teams came following Virginia Tech, and a couple of states, including Virginia, have mandates for these teams. But we're thinking, and I'm just going to say it, Vic, I'm going to predict that in the future, probably not the too distant future, there will likely either be more states that mandate threat assessment behavioral intervention teams. We might even get a federal mandate. I think there are a number of things that could push people in that direction, but the thing, interestingly enough, is that people are already doing it, and if the law requires these sorts of things, all it'll really be doing is validating what's common practice now in the field.
Yes.
And so we have seen some indication. In fact, there's even a law review article on this that's not cited here, but it is out there, that takes up the question: do behavior teams enhance risk of liability or reduce the risk of liability? And I think the common thinking is that a reasonable care institution, one that understands its relationships with students, relies on teams such as BIT teams and threat assessment teams to assist it in making reasonable decisions. I think the common wisdom is these are generally, almost universally, a good idea. And I have yet to see a situation where I've seen a BIT team or threat assessment team make things worse in a way that would really genuinely expose an institution to liability, or worse yet, make students worse off. These are a good idea.
I would completely agree. I think that, initially there was concern, well, if we do it and screw it up, will that put us in a worse position? But I think if it's done in a thoughtful, well-intentioned enough way, it will be seen as a really as a strong positive effort to take care of students, to protect the campus. And I don't think anyone's going to get dinged for making a good faith effort. I was once at an institution that was sort of arguing they didn't want to have a counseling service because if they provided care and it went badly, it might open them to liability. And I asked them if they served food in their cafeteria, and they said yes. And I said, well, students could get food poisoning. So why aren't you worried about that? But obviously you need to take care of the basic needs of your students. You should just do it in a sensible way.
Yeah.
Right? And you'll be well positioned if you make reasonable choices and reasonable efforts. So
Yeah.
unfortunately, we have 5 minutes only, but Kyle, you have anything that seems urgent that we should address?
Wonderful. Well, thank you so much for that. We had a very lofty presentation to put together to talk about mental health law in just an hour. So we'll just kind of stick to the topic of bid teams. And can you talk a little bit about how FERPA impacts a clinician's participation in campus bid teams?
You want to start with that, Peter, or should I?
I'll take it real quick. I mean,
Okay.
because FERPA now permits people in the chain of need to know to be able to get information that they have, you can share a lot with clinicians. Now, the clinicians may be subject to physician type laws, in other words, medical privacy laws. So they may not be able to share information that's medically protected, but they can hear almost anything. And so FERPA is really not a barrier on the bid teams for sharing, and I have very few concerns there. I could give you a more technical answer for that if you wanted to. In fact, actually, I think the institutions could share even beyond their bid teams more broadly than is typical practice, but I do understand the concern to be careful about managing student records.
Right, so I think it's worth reminding people that FERPA doesn't apply to observations of behavior that are not going to be put in a student's transcript, or as they used to say, permanent record, right? So the observation of a student who seems to be, falling off his chair, falling asleep every day in classrooms, that goes to the dean of students or the counseling service is absolutely not a FERPA concern. So just to clarify, as Peter said, for a counseling center staff member, they can hear anything that gets discussed around observations of students that might be concerning in the bid team. They will have another level of constraint about what they can share if the student is being seen at the counseling service, but they can absolutely play a role of advising and directing conversation and making suggestions about management, which might, in the case of a student being seen, it might weigh things the counseling center director might know about that particular student and might not be able to share. Right, so there is absolutely a role. I got a call the other day from a chaplain at a university who also, their question was raised about his participating in the bid team because, again, the claim was being made that he would not be able to share much of what was shared with him by students in the context of a religious confessional. And I said, just like the counseling service director, there's absolutely no constraint in his being there to hear about students who he may be seeing in the context of, some of the chaplaincy activities that in fact aren't covered by the, chaplain-student confidentiality assumption.
And Vic, if I could follow with just a very practical issue that comes up is increasingly bit and threat assessment teams get access to programs like Maxient or Simplicity that do contain education records, including even attendance records. And I've heard a few people get concerned, can I be looking at this stuff if I'm a clinician? And the answer, if you're on the team, is essentially yes. If a student is of concern, you can look at data points that are collected as hard education records that might help reduce or eliminate that risk. So, some of the folks on the phone today may actually be concerned about sort of access to Maxient or Simplicity, and I don't generally have a general concern about that. In fact, actually, I often encourage access to that data so that the clinicians can know what they need to know to provide the services they have.
Right. FERPA allows for the sharing of information when there's a legitimate educational interest in the information being shared among university faculty or administrators. So there's plenty of room to share that information.
You bet there is.
Yeah. Okay. I think we're kind of at the end. Kyle, we're going to hand it over to you. Peter, thanks very much for doing this with us today.
Oh, it's a treat, Vic. It's always great to hear your voice.
Thank you. You
Yes.
too.
Thank you so much to Dr. Vic and to Peter for sharing all of your expertise. And this is definitely not where we are going to end this discussion. And coming up on October 9th, we will actually be joined by Dr. Greg Ailes, and he will be talking a little bit more about legal implications and what this looks like for your institution by way of policy and systems, and going into the practicals from the practitioners themselves, just as Dr. Vic described. And so I also want to thank everyone who participated in today's webinar by submitting your questions. We literally got hundreds of questions that we'll be able to use to shape next presentation. So I want to invite you, as you log off, to fill out the survey that will pop up in your browser once you sign out, and that will invite you to submit any questions you weren't able to ask in the question box. And again, I just want to thank you all for attending today. I wish you all a happy Wednesday. And Dr. Vic and Peter, thank you very much again. And we'll
Thank
see you
you.
all next time.
Thanks, Kyle.
Bye-bye.
Bye, everyone.
Bye. Goodbye to all.